In the last class, we discussed, I guess, till marginal notes. So,
Yes.
thank you. So, today we are going to take up the next important uh, internal aid, and uh, and that is punctuation. So, how important are punctuation, marks in interpretation of statutes? Well, you know that rule says that we are to follow the grammatical rule. Even literal meaning says that we are to go by, the grammar of the language in which the statute's written. So, punctuation, if you take the term grammar in that broad sense, seems to be very much part of that idea of literal rule. But that's not how it is understood. Okay. So, how seriously are punctuation marks to be taken is something that we have to deal with. Okay, so comma, period, whatever. Okay, so all those things. Okay, their presence or absence. What difference can their presence and absence make in the interpretation of a particular statute? Well, the older idea with respect to importance of punctuation under the English system is that they do not form part of that manuscript. Okay, when the royal assent is given to it, so they do not form part of the enacting statute. So, yeah, before 1850, there was no punctuation mark in the manuscript copy of any act that received royal assent. And hence, the courts cannot have any regard to punctuation for construing older acts. So, that's the older idea prior to 1850. Even today, I mean, even as of today, uh, it is taken. I mean, because it comes within the broader idea of grammatical interpretation, so it is to be taken seriously. I mean, obviously it's important, but it's important does not supersede what is clear, crystal clear. Okay, so if the plain meaning is quite clear, then definitely punctuation mark will not alter that meaning. That's what the idea is. So in England, even now, it does not have the same importance as other internal aids, have. So Lord Hobhouse had said that in an old case, okay, had said that it is an error to rely on punctuation in construing acts of the legislature. That was the view. However, the view is changing though. In the Indian context, Justice B.K. Mukherjee had said in Ashwini Kumar Ghosh versus Aravinda Bose, we had mentioned this case earlier as well, okay, where he said that punctuation is, after all, a minor element in the construction of statute, and very little attention is paid to it by English court. It seems, however, that in the vellum copies printed since 1850, basically post 1850, as we discussed earlier, there are some cases of punctuation, and when they occur, they can be looked upon as sort of contemporary expositio. When a statute is carefully punctuated and there is doubt about its meaning, a weight should undoubtedly be given to the punctuation. So that's the view that, yeah, because it is part of the statute, um, so it should be given weight to. However, the idea is that it should not supersede what is clear, crystal clear. Okay, and then punctuation should not be taken so seriously as to negate what is so clear and apparent to the judge. So that's what the idea is, and that's what the importance of punctuation is in construing a particular provision of a statute. So we'll take another important case where it has been applied, okay, and that's by the name Muhammad Shabir versus State of Maharashtra. There are other cases. This will suffice. So this is the case, okay. So in this particular case, we are concerned about Section 27 of Drugs and Cosmetics Act 1940, and that goes like this: that whoever manufactures for sale, comma, sales, comma, stocks or exhibits for sale or distributes. Okay, so that's what it is. So you have manufactures for sale, comma, sales, comma, stocks or exhibits for sale or distributes. A drug without license is liable for punishment. So that's the provision we are concerned about. Now, how is this particular provision is to be read? Okay, so you have stocks, and then you have or, and then you have exhibits for sale. Okay, there is no comma there. So how is that to be understood? So in this particular case, the court held that mere stocking, so you have stocks, after that you do not have comma or anything. Okay, it says stocks or exhibits for sale or distributes. It's held that stocking is not an offense within the section. So mere stocking wouldn't be offense within the section. The court pointed out the presence of comma after manufactures, okay, for sale and sales, as I told you, and absence of any comma after stocks. So stocking in itself will not be punishable under the Act. So it was held that only stocking for sale. Okay, so it says stocks or exhibits for sale. So it's not merely exhibition. Okay, it could not merely stocks. So it's stocks or exhibits for sale. Okay, only in that case will it be punishable. So that's what has been held, that only stocking for sale could amount to offense and not mere stocking. So you see here absence of a comma after stocks made this difference. Okay, so if there were comma after stocks, then stocks in itself would have constituted an offense under this particular provision of the Act. So yeah, so where it is clear, where it is clear. Okay, so in such case, yeah, obviously importance is to be given to the punctuation mark, because that seems to be the intention clearly here. But if the clear intention is otherwise, then more importance wouldn't be given to the punctuation so as to negate what is obvious and so clear. So that's the rule with respect to punctuation. Next is schedules. Okay, now this is not very difficult. You know that schedules are very important, and even under the Constitution. So schedules to statutes are as much part of an act as any other part. Okay, so they are enacting parts. They are very much part of the Constitution, and therefore may be used in construing provisions in the main body of the Act. So in the same way, provisions in the schedule will be construed in the light of what is enacted in the section. Okay, so the enacting portion of the section will be understood in the light of schedules. It does not create much problem. The next important internal aid that is important for us, that is essential for us, is illustrations. Okay, what is the importance of illustrations as an aid to the interpretation of statute? So what are illustrations? You already know these are what are appended to a section, and they illustrate the provision of law as has been explained therein. Okay, so that's what it is. Okay, it explains what the provision basically intends to say. So it's kind of explanation. So what is the importance of illustrations in the interpretation of a particular statute? That is something that we need to look at. The broad understanding with regard to illustrations is that if the enactment is otherwise very clear and it cannot be given an extended or a restricted meaning if we do not have the options on, then it's in such case you will not take the illustration to do so. That's the idea. If it does not permit any extension or restriction, then illustration cannot be taken so as to extend or restrict the meaning of that particular provision. So that's basically the idea. Okay. So this was applied. We have a very classic case by the name Arifin's case. Okay, I'll just type the name. If you remember this, that will suffice. It's an old case. The complete name is Mohammed Saidul Arifin versus Yawai Garg, 1916. So in this particular case, this rule was applied. So we are concerned with a particular provision of Straits Settlement Ordinance 1893, very old act. Okay, and there's an illustration which is appended to it, and it says the question is, what is the date of birth of A? And it says a letter from A's, that is A's deceased father, announcing the birth of A on a given day is relevant fact. So in this particular case, the Privy Council held that diary to be admissible on the footing that a statement as to date of birth relates to the commencement of one's relationship by blood and therefore relates to the existence of such relationship as that referred to in 32.5. So taken to be, from that illustration, you give meaning to the enacting provision of the statute. So it was further said by Lord Shaw that it is the duty of a court of law to accept, if that can be done, the illustrations given as being both of relevance and value in the construction of text. So that's exactly what had been done. So the illustration was taken as an explanation, as an example for how meaning is to be attributed to an enacting provision of a statute. So they are of importance. However, as we discussed, where the clear plain meaning does not permit extension or restriction, then illustration will not supersede that. Okay, illustration will not then justify extension or restriction of that which is clear. So that's the rule. The same has been also applied in another more recent case, okay, although quite old case compared to today, and that goes by the name Jama Masjid versus Kodi Maniandra Devia. Anyway, so you don't have to remember the whole case, okay. So in this particular case, Justice Venkataraman Iyer had referred to the rule as laid down in Arifin's, okay, and said that it is not to be readily assumed that an illustration to a section is repugnant to it and rejected, okay. So that's not what we do. Illustration is to be understood as being in harmony with the enacting provision of a particular statute. And immediately the understanding should not be that, well, illustration is contrary, so it's repugnant. Okay. That's not how it is to be understood. So basically the same rule as was held in the previous case that I mentioned, in Arifin's case, has also been referred to in this particular case. And likewise, this has been applied to section 43 of the Transfer of Property Act. Just a second. So what does section 43 of Transfer of Property Act say? So this deals with transfer by unauthorized persons who subsequently acquire an interest in the property transferred. So a person who does not have the authority or does not have interest in the property, but they are the one who transfer. Okay, an unauthorized person transfer, but subsequently makes gains some interest in that property. So case would be where will is made, but that there is no transfer through will. It's merely space succession is. But subsequently, if interest is acquired after the death of the person, then there is real interest. So what about such a situation? So section 43 TP Act, you guys have already studied, deals with such situation. So it says where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration. Such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. So as long as the contract of transfer subsists, within that, if subsequently any interest is acquired by the transferor, then obviously it becomes relevant for us here. And then it provides illustration as well. What is the illustration? A Hindu who has separated from his father, B, sells to C 3 fields XYZ, representing that A is authorized to transfer the same. So basically not authorized, but representing that. Of these fields, Z does not belong to A, okay? It having been retained by B on partition, so it was not given to A. But on B's dying, A as heir to Z, so A is the heir to Z. So C not having rescinded the contract for sale may acquire interest. So in such case, although the interest was acquired only subsequently, but if the contract of sale subsists, then C will acquire interest in that property Z. Okay, so this is what is there in the provision. Okay, and in this particular case, the same rule was this particular idea of meaning given to the provision based on the illustration was basically applied here. So in this particular case, the Supreme Court took aid from the illustration as I read out to you in section 43 of Transfer of Property Act, and came to the conclusion that this aid provision applies to transfers of spes successionis and enables the transferee to claim the property, provided other conditions of the section are satisfied. So here, based on this, okay, it was assumed that even in case of spes successionis, that is transfer by, in case of will, for example, even in those cases, the said provision, that is 43, will be applicable. So yes, illustrations quite often can give meaning to, the enacting provision. But as we discussed, okay, it is not to be, though, readily assumed that illustration to a section is repugnant to the enacting, section, and should not be rejected at the very first instance. So they are to be read as if one is explaining the other. The illustration is basically explaining the enacting provision. So that's the rule with respect to illustrations. The next important internal aid is proviso. Now, provisos are not exceptions, okay? Provisos, exceptions, and saving clauses they have certain differences, okay? You can say that certain times the provisos are in the nature of exceptions, okay? But provisos create certain specific situations when they become, when, the rule changes, okay, in specific situations. But with regard to exceptions, they create, as the name itself says, they create exceptions. So what are provisos though? Let's look at provisos first, okay, and the rule with respect to construing proviso. So proviso to a section raises the natural presumption that, but for the proviso, had it not been for the proviso, okay, the enacting part of the section would have included the subject matter of the proviso. So if you look at it this way, it seems to be a case of, exclusion, okay, an exception. But then it refers to specific situations, whereas exceptions clearly accept something, okay. So that's the subtle difference that you see between a proviso and exception. So proviso must be read with reference to the preceding parts. So proviso will not in itself supersede the enacting portion. Okay. So it must be read with reference to the preceding parts of the clause to which it is appended to. So you will not read the proviso in absence of the other relevant part. And it is quite possible that it might seem that there is a direct repugnancy, okay, between the two. In such case, what happens? If there is clear repugnancy, then proviso seems to be the case of an exception, okay. But where the section is doubtful, okay, a proviso then may be used as a guide to the interpretation of the said section. But when it is quite clear, when the said section is quite clear, then a proviso cannot imply the existence of words which there is no trace of in the section. So if it is clear, then proviso cannot add what does not exist in the section. So that it can be used as a guide to the interpretation of the section though. However, what is to be remembered that proviso should not dictate the content of the main portion, main section. So proviso is always subordinate to, it's always there to aid, assist, guide, okay? It's not to supersede. So proviso is subordinate to the main section. And it does not enlarge that which is not there, okay, in the enactment, okay? If something does not exist in the enactment, the proviso will not add it, okay? So proviso does not enlarge an enactment unless there is a compelling reason for it, and you will know it ex vis caribus actus. It's not necessary that all the provisos which are provided in the statute are to be given effect to, because sometimes they are also provided just to ensure that nothing is nothing remains excluded. So that is also something that has to be there in the back of mind while interpreting the entire provision. And the idea is that if there is no way for us to reconcile the repugnancy, then what kind of interpretation has to be applied? So in such situation, the construction has to be such that allows or brings into general harmony with respect to the terms of the main section, okay? And the main section should be allowed to prevail. And what about proviso? Can they create any substantive provisions? That depends on the language, okay? Proviso, as you know, starts with the word provided, etc. Okay, but even though it may start like that, it is possible that using the language of proviso, sometimes even substantive provisions are also created. So we have to be mindful of that. And unless the words are clear, the court should not so interpret a proviso as to attribute to the legislature to give with one hand and then take away with another. So proviso should not be read so as to assume that, well, legislature just changed their mind. Okay, in the previous portion, the legislature gave something, and in the very next provision, okay, in the proviso, it has taken away. So that kind of interpretation is also to be avoided with respect to proviso. So that's the broad rule that we have to keep in mind. So Lord Macmillan had said, the proper function of proviso is to accept and to deal with a case which would otherwise fall within the general language of the main enactment. And its effect is confined to that case only. Okay, so it creates special case. Sometimes it is of the nature of an exception, but not all the time. So it is a qualification of the preceding enactment which is expressed in terms too general to be quite, accurate. So it provides qualification to that which is, general, as has been said by Lord Macnaghten. So Justice Hidayatullah had said, as a general rule, proviso is added to an enactment to qualify or create an exception to what is in the enactment, and ordinarily proviso is not interpreted as stating a general rule. So we have discussed all this already. So I'm quite sure, the implication of that is by now very clear. So yes, let's look at one or two cases that will make this thing quite clear to us. Okay, so there is this famous case by the name, with respect to reservation in public employment. You remember the case by the name T. Devadasan versus Union of India, Balaji case, then N.M. Thomas case, and then ultimately Indra Sawhney's case. So we are concerned about, as you know, with Article 16, Clause 1 and Clause 4, which were originally there in the Constitution. So what do they talk about? They talk about broadly the idea of equality of opportunity in matters of public employment. And Clause 1 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. And then 4 says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens, which, in the opinion of the state, is not adequately represented in the services of the state. Now the question is, how is Clause 4 is to be read with respect to 1? Is it an exception to 1? Or is it an explanation of 1? if it is an exception, then it will not supersede 1. Okay, so it was observed in the case, that is T. Devadasan, that this court has already held that clause 4 of Article 16 is by way of a proviso or is an exception to clause 1. So that's what was held earlier. A proviso or an exception cannot be so interpreted as to nullify or destroy the main provision. As we discussed earlier, it is of subordinate value. To hold that unlimited reservation of appointments could be made under clause 4 and clause 4 and would in effect destroy the guarantee contained in clause 1 or at best make it illusory. So it was held, it was assumed as if clause 4 was a proviso, and if it is a proviso, then proviso cannot supersede 1 and so as to completely nullify or destroy. However, as you know, in later cases, for example, in state of Kerala versus Thomas, it was held that 4 is not an exception or proviso to 1, but instead is an illustration, is an example of 1. Okay, so it's an illustration, it's an example of what is there in 1. So in such case, 16.4 is not to be understood as something that negates 1, but something that gives effect to 1. Okay, so if you look at clause 1 as an example of substantive equality, then as representing the principle of substantive equality, then 16.4 is an illustration, is an example of giving effect to that, idea of substantive equality. The same was also upheld in Indra Sawhney versus Union of India. However, in that particular case, you know that the restriction that was imposed was that 50% limit is not to be crossed. However, you see why is this case important is that if you look at it as an exception or a proviso, then the implication is different. Whereas if you look at it as an explanation or illustration, then the implication is quite different. So this case, I think, clearly illustrates to you, how proviso works. So yeah, so it is. So that's what the importance of provisos are. And however, provisos though proviso quite often takes the form of exception, but there are certain differences between provisos, exceptions, and saving clauses though. And what are those? So when we have exceptions created, okay, that is intended to restrain the enacting clause to particular cases, okay. That means it is applicable only in certain cases, okay. But when we have proviso, it is basically used to remove special cases. It is only to remove special cases from the general enactment, okay. So exceptions make it applicable to specific cases, whereas in case of proviso, the specific cases are removed from the general application. That's the broad understanding. So you see there is a lot of overlapping between these two ideas. On the other hand, savings means that it saves all the rights the party previously had, not that it gives him any new rights. So when certain rights are taken away, saving clauses basically save certain rights that already existed. So that's basically the difference between provisos, exceptions, and saving clauses. So in another case by the name CCT versus Ramkrishan Jabir, AIR 1968. In this particular case, just a second. Okay, in this particular case as well, the court said that generally speaking, it is true that proviso is an exception to the main part of the section, but it is recognized that in exceptional cases, proviso may be substantive provision itself and may not be really a proviso in the accepted sense. So as I told you, proviso sometimes takes the form of exception, but sometimes it is also possible for it to create something substantive. So it is enacting part of the statute and is to be read likewise. But proviso is not to be read so as to supersede the main provision of the act. But at the same time, the judges have to be careful that it may not be merely in the form of the exception, okay? It may also create certain substantive rights and duties. So that's the rule with respect to proviso. Now, when it comes to exceptions, sometimes it overlaps with proviso. But exceptions are generally added to an enactment with the purpose of exempting something which would otherwise, fall within the ambit of the main provision. So if you look at it that way, then it's like proviso. Whereas saving clause, as I just told you, when rights are taken away, saving clauses basically retain or save certain rights which would otherwise be taken away. So that's what saving clauses are. However, if an exception is repugnant to the operative part of this section, then it must be ignored. So the same rule as we discussed, the legislature does not give with one hand and take away with another. So if exceptions have to be in the nature of exceptions. Not everything that given by the operative part of this section will be taken away completely in the next part. So it is not to be read as to completely nullify the operative part. It is to be only read in the sense that certain matters are accepted. So that's the idea with respect to exceptions. When certain matters are clearly, accepted, that also implies that no other exceptions were in the mind of the, the legislators. So the idea is that when certain matters are mentioned clearly as exemptions, then that's what was intended to be excluded and nothing else. That's the rule. And what else? Okay, so I guess this has been explained to you quite clearly enough. So one example we can refer to what happens when it comes to exclusions. Okay, and especially in the case of when a statute is repealed. Okay, when the statute is repealed, so what happens then? Okay, what is the effect of the rights? So that when certain statutes are repealed, it is quite possible that certain rights are kept alive. Okay, certain rights are still there. So in such case, it will be referred to as that which has been saved. Okay, so it is quite possible that through saving clauses which are generally appended in cases of repeal and reenactment statute, in such case that which existed before the repealing act was enacted or reenactment statute was created, it basically saves the rights that already existed. So that's basically what saving clauses are. So the idea with respect to saving clauses is that the rights which are otherwise taken away through repealing or reenactment of a statute are saved through the saving clauses, and which form part of the statute. And what is the effect of the same? The effect is that repeal statute remains in force as regards the rights the party already had. Okay, it only retains those rights with respect to the statute which has been repealed and reenacted. However, if the entire saving clause is completely repugnant with respect to the main body of the act, then obviously the enacting portion, the main body of the act, will prevail over that of the repugnant saving clauses. So saving clauses also work just like the exception. If it is completely repugnant, then obviously the saving clauses have to give way to the enacting provision of the act, okay, the statute, the main body of the act, and it becomes void. And you can also refer to section 6 of General Clauses Act, something that we already had discussed. Okay, we had already discussed I think in the first or second classes. Okay, what is the effect of repealing? Okay, and what about the rights which were already created under the act which has been repealed? So General Clauses Act section 6 says that when one enactment is repealed by another, then in the absence of a different intention, the repeal shall not affect anything duly done or suffered. So that which had already been done, okay, under the previous act, as long as it wasn't, repealed, Current now, okay, right now, if the act is repealed, it does not negate what had already been done under the act, okay, which has now been repealed. Okay, so that's the idea. So it is not really an example of saving clause though, because saving clause saves the rights now, okay, whereas section 6 of General Clauses Act is referring to that which has been done while the enactment or the provision of the enactment was still extant. Okay, so that's basically what all the internal aids to interpretation are. Apart from that, you also have definition clauses. Now, with respect to definition clauses, the idea is that it is generally discouraged. Okay, that definition clauses are put there, because then the meaning has to run throughout the act, and where the meaning is not intended, the legislator has to clearly say that, well, the meaning as was defined in the definition clauses is not what is intended to be meant here. So that's the idea. So even with respect to your definitional clauses, generally the idea is that what has been defined will be followed, but one has to also look at the context in which the particular word has been used. So you also have to look at that particular context so as to see whether in such case it is the general meaning as has been defined is applicable or not. So that's it. I think that's all the internal aids and that you have to the interpretation of the statutes.